This is Justin Botillier, CEO of Calyx CPA, based in Medford, Oregon. Today, I want to introduce you to Calyx's newest client manager, Katie Scates, who is a CPA and is a JD, which means she is licensed to work as an attorney, but not working as an attorney. Worked formally as an attorney.
Yes, I
Yeah,
formally worked as an attorney before I went back to school and got my CPA. And
yeah,
now I'm practicing as a CPA.
yes. And that's a good question. Why did you decide to switch from working as an attorney to working as a CPA?
I didn't love practicing law. It's a lot of confrontation and a lot of argument, which I enjoy doing on the one hand, but when it's 24/7, it's a lot.
Uh,
Um, and I discovered when I was practicing law, I was in business for myself, that I really enjoyed the business aspect of my work, but that was what I looked forward to, was like getting to figure out, you know, earnings and expenses and all those things. And I really enjoyed talking to other people about that. And I quickly realized that I had picked the wrong profession. Prior to law school, I was a paralegal and a bookkeeper for law firms, and I loved my job. And so I thought, well, that means I want to go to law school.
yeah.
And it turns out that law school was not for me.
Uh-huh.
That being said, I'm super grateful for the education I got and the knowledge I have um, from that experience, because it does help me every day.
You got the accounting bug, really, though.
I do. I love accounting. I love playing with numbers, and
Yeah.
attorneys don't play with numbers. They don't think in numbers. They think in law and facts and
Hmm.
not numbers.
Yeah. But with that said, you have experience and you do
I do.
know things about law.
I do.
So we have to be very careful for us as the team of Calyx, and as well as you, the people who may be watching this video, the clients, to not assume that Katie is giving you making legal recommendations, right? It
Yeah,
seems like
I
all
am.
attorneys always say, this is not advice, et cetera, et cetera. And I think even on your signature, we've got to add some extra,
We
like,
do.
just because you have the JD behind your name doesn't mean that everything you say is legal advice.
So anything I say is not legal advice.
Anything you
If
say
you
is
if you
not
want
legal.
legal counsel, then please do seek it out. It's important to have good counsel if you feel like you need it.
But you can give out CPA advice.
I absolutely can give out CPA advice.
I'm always giving legal advice, but I get away with doing that because I'm not a lawyer.
You aren't giving out legal advice. You're giving out advice on tax
Information.
law as it applies to accounting principles so that you can do
Yes.
tax work.
Yeah, yeah,
Yeah.
yeah. It would be like taking advice from a comedian. Like, don't. You know how there's always good at comedians out there, and they're always like espousing their opinion, but it's like, why are we listening to this person? Anyway, just an idea. But I also want to take this time, Katie, not only to introduce you to the people who might watch this video, who are our clients, and hopefully they do, but also to get your opinion about some of the activities that are being conducted on the legal side of things by the cannabis industry, particularly this article that came out recently, a couple weeks ago, and I've been meaning to actually get, to comment on this to the greater audience. And but essentially, it's what's happening. What is the industry doing to challenge 280E? And this came out a couple weeks ago. Marijuana Moment, which happens to be my favorite publication, I guess maybe next to like NJ Biz, but these guys seem to do a really good job. And in it, they talk about how some of these MSOs are challenging their well, actually, maybe I can hand it over to you, Katie. You might be a little bit more eloquent than I on this. But I do know that they went to court to try to overrule at least what it appears to me, overrule the Controlled Substances Act's application to these states that have their own cannabis regulation. And now they're appealing, but what does that mean? That's kind of what I'm looking for.
Yeah, so we talked a little bit earlier about the differentiation between where this case started and how it ends up in the Court of Appeals for the First Circuit. So the First Circuit is basically New England. So you start in a district court federally, so the federal district court, and that's who heard the case initially and declined continuing on, declined making a ruling, dismissed the case. And they've appealed the case to the U.S. District Court, or the U.S. Circuit Court for the U.S. Court of Appeals for the First Circuit. There you go.
Okay, and what does that mean? Like, obviously that we're trying to get back up to the Supreme.
Yep. So you have the district court at the bottom. It's your it's your trial court, basically. It's where you start a case. It's now in basically the federal court of appeals, essentially.
Okay.
For the district that encompasses New England and Puerto Rico.
Yeah.
At the Court of Appeals, the court can send it back to the district court and say, district court, think again. Hear it out. Or they can say, yeah, we're gonna issue a ruling on it, and they can do that. They can say, no, we're agreeing with the lower level court. We're gonna dismiss it as well.
And they dismissed it because of the 2005 Supreme Court ruling, where they pretty much ruled in favor of the government, saying that, hey, we need to have the authority to enforce drug policy across the United States, and just because it's legal in one state doesn't mean that it's not subject to the Controlled Substances Act. And so now these large companies are kind of getting fed up with this. Like, I think the whole industry ought to probably be being fed up with this unfair treatment, aka 280E, and this handful of multi-state operators. Let me see if I can find their right here.
Like Canna Provisions, Wiseacre Farms,
Verano Holdings. Yep. Canna Provisions was one of the ones that originally filed.
Yeah.
So I think it's moving, which is really good.
It's moving, and so we'll see what the Court of Appeals says. If the Court of Appeals issues an opinion not in the plaintiff's favor, it basically goes from there to the Supreme Court. And so I think essentially what they're trying to do is work it up the chain, and get a real ruling on, does 280E really apply? Is cannabis correctly scheduled under the Controlled Substance Act, making it, fall under 280E? I think at this point, it's the feds haven't really enforced, they've allowed cannabis into the District of Columbia. They're not spending federal funds to enforce, cannabis, laws against cannabis. And so is it really, are they really?
That's kind of the point that I've been trying to get out for a while now. And Katie, you're new to working with us, so you haven't necessarily drank the Kool-Aid that we've been espousing all these months and years, but it sounds like you kind of feel similarly. You wouldn't have probably taken the job had you not.
I do
similarly about
similarly, this. and I have not drank your Kool-Aid yet.
No.
but I have previously worked in cannabis accounting, and so I do come from a background of working with the industry,
Yes.
and the unfairness of the application of 280E.
Yeah.
So
I mean, to me, like, I always say this, but I don't know from a legal perspective if this is a even logical argument. But I always fall back to the idea whether or not cannabis should have ever been considered a Schedule I drug under the definition of the Controlled Substances Act. And therefore, I mean, just from that, like that's like I like things reasonable. And if it's not reasonable, then I'm like, then there must be something fundamentally incorrect about this. And should we, as an industry, continue to allow ourselves to be penalized for this, essentially this injustice? Now, that's my opinion, and I know that's not anything that you can necessarily, take to the bank. But am I like, and you can correct me, like I'm totally fine with everybody hearing this, but let me know if I'm like being unreasonable here.
I don't think you're unreasonable, because I do think it starts with the premise that, should cannabis have really been a Schedule I in the very beginning? Because
Yeah.
probably not really. It's needed to be rescheduled for a long time, and it has not been rescheduled to date. There's hope and talk that it will be, but there's no way to. You have to push change if you want change. So
Right.
someone has to be willing to take the risk to challenge it. And the only way to challenge it really is to get cases before the courts. And to get cases before the courts, you have to have a reason to get there.
Mm-hmm.
You have to have standing to bring something. So you have to have some harm done to you by 280E or something else to even get to the courts. So there has to be grounds to bring a suit. And the only way to do that is to take steps towards challenging the application of 280E as it currently stands.
Yeah. Yeah, I mean, the best that we could do is continue to do what we're doing, which is give cannabis businesses the option to continue to comply with 280E and reduce deductions, or now, potentially move forward without reducing deductions like many of these larger companies are doing. And then hope and cross our fingers that the IRS doesn't like get punitive on us, which I honestly don't think will happen. The IRS has never struck me, like in the 20 years that I've been working in the accounting industry. I've never felt like the IRS has been punitive. And that's one of the fears that a lot of people have, is like, well, as soon as you try to, move forward with not reducing deductions for 280E, even with a reasonable basis argument, they're going to audit you. That's what when I read articles and stuff, there's professionals, they're saying that, hey, they're going to audit everybody. Everybody's going to get audited. If you try to amend a return, you're going to get audited. And that would be like kind of a question I have, and I don't, Katie, you probably can't necessarily answer that. I wish somebody could, but will the IRS actually get punitive on people? Will they be like, we're going to make these people's lives miserable because they're going against the grain, which is we didn't give them the authority. For those people who choose to do that, again, like we're not supposed to advise that people do this. It's just that we give people the option to do it. And then I always tell people, they always ask me like, what's the risk? And I'm like, just assume the risk is high, because we don't know what that is at this time.
Yeah, there's no way to know what the risk is. And ultimately there's no way to know what the IRS will do. At the end of the day, they're going to do what they're going to do. And we're going to hope that they're not going to be excessively punitive.
Yeah.
And hope that, it gets rescheduled soon, and that 280E is not an issue.
Right. I want to share my screen again. Here's another one another article by MJ. Marijuana Moment. This came out like a week later. Nixon admitted marijuana is not particularly dangerous in newly discovered recordings. Now, I thought, well, this could be AI, right? Like AI is crazy.
Yeah.
What you can do with it. You can easily put words into anybody's mouth. But I listened to it. It sounds really legit. And I probably need to fact check it, but I kind of trust these guys like to be espousing actual information. But he definitely says that he didn't think it was particularly dangerous. And he was even saying that in this that it probably ought not to be included in Schedule 1, but then that there was like a commission or a board that was like, no, you definitely need to put this in with all the rest of the dangerous drugs. So this is another interesting article. Nixon admitted marijuana is not particularly dangerous. And there is audio in there. You can hear it. You can hear him talking about it. And I'm trying to, where is it? Oh, I don't know. It's a long article. Maybe I'll leave it up to you to listen to it. But Nixon admitted marijuana is not particularly dangerous and newly discovered. You could pretty much just Google it. And Katie, I'll Slack it over to you.
Yeah, please.
Yeah. But anyway, it's another one of those reasons why, like, I think if anything should be challenged, the question is, should it have ever been a Schedule 1 drug? You know?
I mean, that's the, no medical use. I don't think
Yeah.
that that's
Right. HHS said that it should have been Schedule 3 now or less. And then one of the other, oh shoot, I can't think of it right now, but another medical like establishment was saying, yeah, it definitely isn't as dangerous as opioids. You
I mean,
know?
that's some of the drugs that are in Schedule 1 when you look at them in comparison to cannabis. It's
Yeah, absolutely. And now we're now there's psilocybin here in the state of Oregon, so Colorado is about to they're issuing license, they're accepting applications, and they're going to be, I think they're accepting applications as of January 1st, and then they're going to be issuing licenses after that. So they're going to start operating too. And again, like that's still Schedule 1. So I don't know. Seems like there just needs to be a lot of reforming going on.
yeah, hopefully.
Thank you, Katie.
Thank you.
All right. I'll see you later.
Bye.